and good evening. I'm Melisa Idris. Welcome to Consider This. This is the show where we want you to consider and then reconsider what you know of the news of the day. The government is reviewing the controversial Security Offences Special Measures Act, or Sosma, with plans to refine certain provisions and present them during the next Dewan Rakyat sitting in July. Now, Sosma is a controversial procedural law that allows for up to 28 days of detention without judicial oversight. The Home Ministry says that it will be fine-tuning this law to strike a better balance between national security and detainee rights. But the question is, will these reforms truly be meaningful, or will they leave the core problems of Sosma intact? Joining us on the show is Sevan Doraisamy, who is the Executive Director of Suara Rakyat Malaysia, better known as SUARAM. Sevan, thank you so much for being on the show with me. The Prime Minister has ordered the Home Ministry to review Sosma. How extensive of a review do you expect it to be? I mean, are we thinking of a fundamental overhaul of this very problematic law?
Hi, Melissa. Thank you. Yes, in fact, to get the Home Minister to come back with the proposed promise on Sosma amendment it's quite hard. This is also because the initial process of amending this with the current government started in 2022 and 2023. During that time, they have appointed Ram Karpal. He was the former Deputy Law Minister. And then there was a few round of consultation happened. And then after that, once it's done, there's no movement we heard. So it was silent until, the recent protests and also the arrests. It triggered few commotion in the parliament, and then the Sosma back on radar. Again, to answer your question, yes, it is fundamentally important to address the most of it in terms of under Sosma, because there are so many provisions under Sosma is very controversial, and it's need a thorough attention. So hence, it has to be a thorough review on Sosma. Although our position is we don't want this Sosma procedure, because we already have a CPC as a procedure. But at the same time, once you wanted us to engage and discuss on the amendments, we can still focus on those amendments still.
So what we've heard so far is that the Home Ministry is outlining 3 key areas that it will review. It will review in terms of assessing Sosma. So one of the things has been the 73 offences under Sosma that determine whether or not that should remain unbailable. Maybe you can talk to us a little bit about what that means for it to not be a bailable offence, and what principles you think ought to guide the Home Ministry's review of that provision.
Okay, the first principle is who is deciding whether someone can be granted bail or not. So that has to be a court's power. So the power should be within the court and the judges. So there are 3 things, right? This is also I learned along the way. I'm not a lawyer, but there is like a bailable, and then there's like a non-bailable and unbailable. So bailable is it's when it's written as a provision, bailable offences like a theft and all that. So there will be a fine, or if you plead guilty, you pay the fine and then you're out. Or if you wanted to go to the court process, trial process, you pay the bail, and then you just wait for the trial ending. The non-bailable is the court's discretion. So the judges can decide whether, with all the circumstances and evidences, the judge can decide whether you need to be granted bail, you can be granted bail or not. Unbailable, it's not at all bail. So there is no bail at all. That's unbailable. So under the Sosma, what our position is, you only can have 2 categories, not 3. Bailable and non-bailable. So let the judge and the court decide on whether someone can be granted bailable under the non-bailable list.
Okay, that's interesting. I didn't know there were different categories under non-bailable and unbailable. The other area of review that's been mooted by the Home Minister that we've heard in Dewan Rakyat has been proposing a special court to handle Sosma cases. What do you think might be the benefits of having a separate court would be? And also, can you help us think through whether this is a good idea? Could there be unintended consequences from this?
Okay, so there is a debate going on, right, to whether there is a need for special court. So the fundamental point here is it has to be an open court. So it means family members should be allowed, the observer should be allowed, because you're talking about national security, you're talking about gangsterism. So everyone have a collective responsibility to secure our environment, right? So we also need to know what is happening around us. So it cannot be in a closed court. So it has to be an open court. And here the call for a special SOSMA court is because in most of the SOSMA cases, while there is no bail, the dates to the trial at the court, it's always long wait. Like for example, the SOSMA TR, the current case where they protested in front of Sungai Buloh prison. So they were arrested in March and also September, August or September in 2024, and the court case was set in 2026. So until then, you can't bail them out. So what happened? And most of them are breadwinners. And what happened to the family, right? It's a whole struggle and put the family further below. So they are mostly from the B40. So the special courts, the idea here is to hasten the process. So as one of the promises, within a year, so the court case will be either finished or ongoing and all that. So that's the reasoning why people, some of us agreeable with the special court. So one is fasten the process. The second one is it have to be heard openly, and also the judges in the special court given the right or power to decide on the bail and bailable matters. And also easier to general public understand what is SOSMA is all about and how is the process is going. So in a way, I'm also seeing that there are some positive area when you have a special court here.
Okay, all right. So that's the one side of the debate. Interesting to consider. Have you heard anything about whether the Home Ministry is reconsidering the 28 days of detention? I mean, currently under the Criminal Procedure Code, it's 14 days. Have you heard anything about the duration of that period?
Yes. So this is very interesting point. This is because the current government, when they were in the opposition, Melisa, this 28 days is a sunset clause. Every 5 years, it will come back to the Parliament for a review.
So 2022 was when it was passed
to the
again.
Parliament.
Yes, that's right.
That's right. In the first sitting, sometimes in March, and Hamza was the Home Minister, it was brought to the Parliament. It was voted out because there was like a 40 over numbers of members of Parliament who did not attend. So there was like 86 to 84, if I remember correctly, and they voted out. And the 86, mostly from the MPs with the current government now, then they were on the opposition side, right? So now they are with the government, and then they kind of like, and after that, Hamza brought it back to the Parliament to review that, and then they got it back. So in between, the IGP came out with a statement saying that these are the other laws we can still use under CPC to go on with it without that 28 days. So you can see that the debate, right? Without the 28 days, there are enough provision to go ahead. So that's why we stick to the CPC when you have 14 days as a max for the serious crime. And in between, after 7 days, you have to brought to the magistrate for a judicial oversight so that the judge, the magistrate can see if there is a torture practice or there was a forced admission and all that, right? Without that, it's going to be very difficult because under the SOSMA can override the Evidence Act, which confession or forced or what your admission can go against you. So if you say you were forced to do it, you were tortured to do it, it's not admissible. So that's a gray area there as well. So that's why that 28 days, I think it's too long. after 7 days, you need to be brought back to the magistrate. So there can be 7 plus another 7. 14 days is enough. If 14 days is not enough, I think we need to empower the police investigation system with proper equipment and proper support for the police, so that they can enhance their investigation and fasten their investigation. That need to be focused.
Well, SUARAM and you personally, Sevan, have long been highlighting the problems with this law, with this procedural law. Can I ask you whether you are going to be engaging with the Home Ministry as they do this latest review? Will you have any be able to provide any feedback or any of your input into the refinement or the review of the law of Sosma?
Yeah, we are happy to do it. If there is another opportunity, we will sit in the committee and give our opinion and also. But this is also important to include representative from Bar Council, few civil society, and also from other side. So it has to be a proper engagement with all the stakeholders, which was done during Ram Karpal's meetings with many stakeholders. So there was a few rounds it happens, right? So we already have that full document on that. From probably this committee can take from there and also continue to focus on which area they wanted to reform.
Okay. Do they need to set up another committee? Clearly, there's document, there's been reviews, we have the information and the data and the the assessment. Is there a need for a new committee at this point?
So that's why our initial reply was, okay, you don't need another committee. Hence, in the Parliament, the Home Minister says, okay, there will be no more like the regular committee, but we specifically focus. So what is most important with that committee, you need to have a timeline. So our take is, can we have it in the next Parliament sitting, which is, I think, July. Right. So the role of the committee will be just fine-tune the gray areas with the proper discussion. That's about it. Don't start all over again. So I believe what Ram Karpal have done and submitted to the cabinet good enough to go. So all we need is just get everyone's consensus with some fine-tuning areas to go ahead.
Sevan, always a pleasure talking to you. Sevan Doraisamy from SUARAM there. We're going to take a quick break here and consider this. We'll be back with more. Stay tuned. Hi, welcome back to Consider This. I'm Melisa Idris. Let's continue our discussion about Sosma, the Security Offences Special Measures Act. This is after the Prime Minister directed the Home Ministry to, quote, review and make improvements to Sosma, end quote. Now, Sosma is a controversial procedural law that allows for up to 28 days of detention without judicial oversight. So joining us now to discuss how this law might be improved is Suhakam Commissioner Ragunath Kesavan. Ragunath, thank you so much for being on the show with me today. What do you make of the Home Ministry's promise to review Sosma?
I hope that they follow through. That's one thing. This is one of the promises for legal reform. Mm-hmm. And about time, I think the issues for me, as you mentioned, there's no bail for Sosma, and then the remand period of 28 days. And then, of course, you have logistics issues. A delay in the hearing proceeding takes about 3-4 years before hearing can even commence. And a cruel part of that is that even if you're acquitted at the first instance, on appeal, you're still in jail, in remand, until the final appeal is concluded. So that is extremely, extremely harsh. Even for murder, I mean, if you're acquitted and you go out. Whereas for Sosma, you have that problem. And I think more importantly, a study done by SUARAM has also said, I mean, what is very important to also look at is in the 10-12 years of Sosma, 2013 to 2025, they should do a study on how many people have been charged, how many have been arrested under Sosma, and how many cases have completed right up to the final court of appeal, for instance. That has to be done. You must have data. That's number one. And our Suhakam's study shows that most, if not all, of the Sosma detainees come from the B40 group. So tremendous social problems in terms of families. You break up families because the sole breadwinner is remanded. And the concern I have is this: where are all the top of the bigger gangsters and warlords and drug pushers and traffickers? None of them have ever been charged under Sosma. So eventually what happens is that the level of people who are charged are at the P40 level. It seems to be like the easiest to charge, easiest to convict because they cannot afford lawyers and what have you. Whereas the big players, the bigger fish, none of them have ever been charged under Sosma. So the effectiveness of Sosma has to be looked at as well. Because this is high time. If you're going to do a review or revision or repeal or whatever it is, it's very important to carry out a study based on data to show how effective has Sosma been.
This review by the Home Ministry, is it just rearranging deck chairs on the Titanic? Is it not addressing the real issue, which is an inherently problematic law?
It is. I agree with you. It is inherently problematic. So, but I think what we have to do is to push the government to give us data.
Okay.
So what's very important is to tell us, in the 12 years of Sosma, has it been successful? And who are the people you have arrested? And who have you charged? Where is the traffickers, the drug traffickers, the human traffickers? Where are all those people, the illegal gambling syndicates?
What would make for a successful, what would make for success under Sosma?
I think one is political will. The reason is this: we look at the arrested persons and in Sosma, they're all B40. They would have been involved in some minor gangsterism, thugs, for instance, at a very low level of operating. They are not big timers. Obviously, they are not, because the moment they are arrested, their families are having serious difficulties in terms of income as well.
So, sorry, Ragunath, if I may rephrase my question and word it properly or word it better, how would we measure if Sosma has been successful? What would that look like? How would you define success?
For me, if you have, technically you have dismantled big syndicates, drugs, trafficking, human trafficking, women, trafficking women and children. If you have managed to catch the illegal gambling, for instance, it's so rampant. It's a black economy in Malaysia. Is there any evidence to show that, other than the petty gangsterism offences, have you actually, Sosma, has it been successful in combating serious crimes in terms of not only violent crime, but also trafficking, for instance? So we have not come across, when we did a study of persons remanded and charged, all of them come from the B40. So that is a bit of a concern for me, because again, similarly with the Dangerous Drug Act, you only get the couriers. You don't get the drug kingpins as well. So effectiveness of a law has to be looked at. How effective the law would be, and what is the response from the enforcement agencies to say, look, this is successful because we have managed to dismantle huge crimes, managed to dismantle illegal gambling and things like that. If it's a matter of, minor gangsterism, there are enough laws in Malaysia to charge them under. So that's our concern.
Right. Ragunath, what do you make of the fact that the Home Ministry is considering a special court for Sosma cases? How are you weighing the pros and cons of that?
It's a good idea, because what would happen is that you can fast track these cases. So now, because there's no bail granted for most of these persons, it takes 4 years before your matter commences hearing at the first level. So by the time you go on, it probably takes 10 years. So what I'm saying is that, I mean, the idea of having a special court is good, but inherently there are problems with the law in terms of the application, in terms of the abuse and the processes that is involved. So those areas has to be looked at as well.
Okay. So the fact that the Home Ministry is now also planning to review the offences under Sosma that should remain unbailable, how do you view that? What are you hoping they will review and reconsider?
It should, I mean, if you keep Sosma, it should be on the basis that this criminal procedure code applies, the usual situation where bail is granted, not special circumstances that, is decided by the prosecution. For instance, I don't want to grant bail, for instance. So that removes judicial oversight. That's our concern as well.
Okay. Is Suhakam involved or in consults or has given input to the Home Ministry about this for this review? I understand there's a special committee that's going to be set up. Are you going to be Suhakam going to be participating?
I mean, if we are invited, we would definitely. But I mean, our public positions on Sosma is very clear. Suhakam's position. So, and we are pushing for data, effectiveness of Sosma. That's very important. Instead of doing cosmetic changes, we have to look at whether it's been successful and has it achieved what it was supposed to do when it was legislated and enacted in 2013. So that's very important. I mean, the government must answer this question. What was the data?
Right, well, just going off on the Prime Minister's remarks in Parliament and the Home Minister's remarks in Dewan Rakyat, it seems like there is no plans to abolish this law, but to improve it, refine it, fine-tune it, whichever term they want to use, because of this need to, as they say, balance national security concerns. So when you think about that narrative, Ragunath, what are the absolute minimum changes that need to happen under this Sosma review that will prevent this this procedure to be abused, to be misused?
Remand. You should have 28 days. Remand is too long. Bail must be granted as per provided under the CPC. And if you're acquitted the first instance, you should be released. You can't be held until the final appeal is completed. That's harsh and cruel. So, I mean, these are the basic minimum that they're looking at.
Okay. Ragunath, thank you so much for being on the show with me. That was Suhakam Commissioner Ragunath Kesavan there, wrapping up this episode of Consider This. I'm Melisa Idris, signing off for the evening. Thank you so much for watching and good night.